Hi everyone, my name is Yogita. I welcome you all to this free introductory session of civil procedure. I'm a barrister and solicitor in Ontario. I had passed civil procedure as one of my elective subjects. In today's session, I will not be providing any legal advice. So firstly, I will discuss about the civil procedure package in order for you to understand what to expect once you register with us. Then I'll provide you a quick syllabus overview and skim through a few topics, and thereafter I'll show you my material and share a few hypothetical questions that I've created out of the bundle of questions prepared for you. So let's get started. Once you register for the civil procedure sessions, you will receive the following package. I'll be providing you minimum 10 hours of dedicated live sessions to cover up the full syllabus. So this way you get time to clarify your doubts and be well prepared. You will also have access to the recordings of these sessions so you can follow on your own pace, access it at any time and revise the concepts over and over again. I prepare some brief outline of the material that I use for the live sessions, which I will share with the regular students. Also, NCA syllabus case laws are discussed all through the sessions. I will also be going through the Ontario rules of civil procedure. I also use sometimes flowcharts to explain the concepts so it can break down the complicated concepts into simpler terms. There will be live exam practice session as well, and a recording of the live exam practice sessions is also shared with the students who are registered with us, as well as we'll be sharing 6 fact pattern questions which are hypothetically drafted along with their analysis. There will also be 6 essay questions which are hypothetically created along with their analysis. So this is what you can expect once you register with us. If you look at the slide in front of you, I have listed below for your ease of reference all the topics covered in this subject. Now let's look at topic number 1, background to the civil dispute resolution process. Now, in this topic, we will understand what do you mean by civil procedure, what is the purpose of civil procedure, okay, and what processes to be followed. So basically, civil procedure is a process that needs to be followed in the litigation of civil claims. Now, what constitutes civil claims? It's basically a lawsuit between two parties. Now, why does this lawsuit arises? There may be many reasons. So there may be disagreements in contracts, there may be issues and disputes relating to property, or there may have been a personal injury, also termed as torts, so long as it's not criminal. Now, topic number 2 talks about basic institutions and processes. Now, here we look at the structure of the Canadian codes as well as the overall litigation process. Now, in Ontario, rules of civil procedure are accomplished in the Codes of Justice Act. So, topic number 1 and 2, okay, these give you a general understanding, or you can say a foundation of the basic structure of the civil litigation system. It talks about the dispute resolution, purposes of the system, the structures of the Canadian codes. Topic number 3, limitation, capacity, standing, and parties. Now, here we'll be looking at concepts such as what is limitation and who are the parties to a civil dispute. Topic number 4 talks about general matters, proportionality, etc., commencing, proceedings, and pleadings. Now, there are a lot of concepts to understand here. We will be studying what is a statement of claim, statement of defense, reply, counterclaim, cross-claim, third-party claims. Next is topic number 5, class proceedings. Now, we will look at what constitutes certification. Topic number 6 discusses about jurisdiction service. Now here the emphasis is on the jurisdiction, it's on the jurisdiction aspect, as well as the deadlines and the various processes to be followed. Topic number 7, discovery, evidence, and experts. So the whole purpose here is to obtain information before the trial. Okay. Now here what happens is that the parties, they meet in a room and they disclose documents or the evidence to each other. So whatever are the relevant documents, they are disclosed. Now why they are disclosed? It's basically to assist in the preparation, of the trial and to eliminate any surprises. Topic number 8 deals with case management, pre-trial conferences, and ADRs. Now here we will learn from the procedural perspective. Topic number 9 talks about motions and interlocutory relief. Topic number 10 discusses how a claim can be disposed of without full trial. So that's why it's called disposition without full trial. Now here we'll be looking at concepts such as determination of an issue before the trial, summary judgment, and as well as default judgments. Topic number 11 deals with trials, applications, references, judgments, appeals. Topic number 12 deals with pluralism of participants and processes. Topic number 13 discusses cost and the fees, concepts here. So we will be looking at what constitutes settlements. Topic number 14 discusses access to justice. Topic number 15, other topics and issues. Now, the way the topics are aligned, they flows with the procedural stages. Okay. So, as we all now know that civil procedure is where you'll be learning how to resolve disputes and use all the different processes. So you do understand that there will be some triggering event. There may be some dispute or breach of contract or any other that's termed as a triggering event. So once a triggering event takes place, okay, you have to ask yourself, okay, what next you have to do? Okay. Now, one of the aggrieved parties, the parties who's unhappy, whose rights have been breached, they may want to take a legal action. Okay, so this party is termed as a plaintiff, and the party you'll be, submitting your claim or you'll be suing is called the defendant, because they have to defend themselves. So now, before you begin all this, you have to analyze, okay, who do you want to sue? Where do you want to sue? Okay, what do you want to sue for? Okay, because you have to understand that, what are the common instances basically are in case of, negligence. Somebody may have trespassed your property, somebody may have damaged your property, there may be a breach of a contract, or let's say if an employer wrongfully terminates, the employee. So anywhere the aggrieved party's rights are breached, that's where you have to see if the civil claim can be filed or not. Then you look at how it's going to be done. Okay, so these are some of the questions we will be dealing with in this whole subject. Now, all these 15 topics are a projection of the Ontario Rules of Civil Procedure, the practice directions, and the various statutes. I will show you quickly the Ontario Rules of Civil Procedure in the next slide. Here are the Ontario Rules of Civil Procedure under the Courts of Justice Act. You can see it stated as RRO, which means these are the revised regulations of Ontario. There are overall 77 rules that form part of the syllabus, which we will be studying in our regular sessions. So I'm just going to scroll here, and you can see the rules are actually stated on the left side in numeric forms. They're indicated by the number, and rule number 77 is the last rule. Now, what NCA expects you to know by the end of this course? Okay. So firstly, you should have a good understanding of Ontario's rules of civil procedure, the practice directions, and the various statutes. So now the practice, in regards to practice direction, it is nothing but a supplemental protocol to the rules. Okay, it's like a device where you regulate minor procedural matters. It's like an official announcement by the court, which states down the rules as to how it should function. So along with civil procedure, you are expected to understand the practice directions as well as the statutes. Now, by now, you all know that civil procedure involves resolving disputes. Okay, it is a process of understanding the general concepts. You should be able to synthesize, apply, and critically evaluate the concepts by looking at the rules. But you don't stop there. Okay, you have to go beyond it. Now, beyond it, it means you have to look at alternative processes, how access to justice can be justified, and professional responsibility, meaning you have to look at the practice direction and the statutes as well. You should be able to think what works, what doesn't work, what are the options and alternatives that might be available. Now, in your syllabus, for every topic, those 15 topics we just went through in the previous slides, the syllabus mentions that either there are certain topics where the syllabus emphasizes that, you can skim through those topics. Skim means you do not need to do a close reading, but just, just read, browse through, just get an understanding and move on. And for certain topics, the syllabus emphasizes that further optional materials only if you're looking for additional coverage of a topic. So whatever this civil procedure has covered, that is enough for you to understand for that particular topic. And the syllabus has provided you with further optional materials only if you're looking for additional coverage, if you want to raise your knowledge bar to that level. Now, there are some case laws listed in the syllabus. Okay, I would like to heavily emphasize on these case laws. When you are analyzing the situation, you should be able to correlate the relevant case law. And all the case laws listed in the syllabus will be taken up during our regular sessions. Now, let's skim through a topic quickly as part of this session. Thereafter, I'll show you some hypothetically drafted facts and questions and the rest of the material. Topic number 3, limitations, capacity, standing, and parties. Now here we will be discussing some new concepts such as what is limitation, what is the principle of discovery, and understand what's the purpose of it. Now to begin with, let's take an example to help you understand this. Let's say you and I were neighbors and I did some damage to your property. Many years passed by. Let's say after 20 years, you wake up one day and say, oh no, that was a damage. I want to sue. You want to sue me, okay, for the harm that I did to you somewhere 20 years back. Now, the question to think here is it fair, for me that anybody can get up after X number of years and come to sue me? Or isn't it unfair for you that you have lost your right to sue? So we will analyze the situation from the perspective of the prescribed time period within which the lawsuit should be commenced. If not, then the legal claim extinguishes. Now, the purpose of this thing is to strike a fair balance between the rights of the person who want to bring the claim, which is you, in this case you're also termed as a plaintiff, and myself, which is the defendant. So we will look at section 4 of the basic limitation period, which is 2 years of the day on which the claim was discovered. Now, unless the Act provides otherwise, a proceeding shall not be commenced in respect of a claim after the second anniversary of the day on which the claim was discovered. Now we will also look at Section 5 of the Ontario's Limitation Act 2002, which talks about the discoverability principle. Okay, so in such scenarios, these are called like the triggering events. Okay, so you will have to analyze from the perspective of when the clock for limitation begins. You have to discuss about the discoverability principle and analyze if it applies or not. Now, this topic also covers other concepts such as what do you mean by standing? Okay, it means like who is eligible to seek remedies, in what interest is the claim being filed. Now, who are the parties to a lawsuit as well? You can be joined as an intervener. Intervener is basically a non-party who requests to intervene to be added as a party as per Rule 13. Or, it can be either as an interested party or he may act as a friend of the court, also termed as amicus curiae. Now, this is basically just for informational purposes that the person may want to be added as a party. Now, we will discuss this in detail in our regular sessions, as this itself is a huge topic to understand. Okay, again, so this topic deals with what you call as a trigger, which is the onset of the civil dispute resolution process. Okay, now just a personal opinion here. I personally feel that the civil procedure is a very interesting subject. Okay, now here NCA would want to see how you figure out which rules to apply. The whole focus is on the procedural aspect. Okay, but you don't have to worry, as my goal is to help you understand the subject in a very simple and logical manner. Now, once you understand the logic behind the concepts, you can crack any scenarios, and we are always here to help you with this. And also, I have a good news for you all. Now, civil procedure is one of the foundational courses in your barrister's preparation. I won't go into much details here, as this is the NCA session here, NCA preparation session, but my job as a teacher is to make you realize that make sure you study this subject very thoroughly, because it will help ease out things and understanding once you reach to the barrister's level. So again, in short, as per the civil procedure syllabus, the course has been outlined in such a way so that you have to read the rules, you have to understand them and follow them in a civil dispute resolution process. Now, I will be quickly showing you the hypothetical facts and the rest of my material. I will help you better understand how it's applied by sharing some hypothetical scenarios and examples in my regular sessions as well. So with this, I will end this free introductory session on civil procedure. I hope you have enjoyed this session as much as I did, but stay tuned. I'm going to be sharing rest of the material shortly. I hope to look forward to seeing you all in our regular tutoring sessions, and thank you for taking the time to view this recording, and good luck with your preparations and upcoming exams. In case you have any questions, you can always reach out to us. Take care.